Hello and welcome. You are listening to an informed take on current events brought to you by law students and staff of Queen's University Belfast. This is LawPod.
Welcome to LawPod, a podcast produced by staff and students at the School of Law at Queen's University Belfast. This is the second episode in the Legal Lexicon series, which looks at abstract legal concepts and explores them in a more accessible format. But this episode is different. Today we will look back at the career of Lord Kerr, who was a justice of the United Kingdom Supreme Court from 2009 until his retirement in September 2020. Before that, he was the last ever Law Lord appointed to the House of Lords, following his tenure as Lord Chief Justice of Northern Ireland. Lord Kerr sadly passed away in December 2020, leaving a remarkable legacy as one of the greatest and most consequential judges in Northern Ireland and UK history. In this episode, we will hear from 4 people who knew and were influenced by Lord Kerr. Joining us today are Lady Brenda Hale, former President of the UK Supreme Court, Professors Claire Archibold and Brice Dickson, both of Queen's University Belfast, and Miss Monye Anyadike-Danes QC of the bars of Northern Ireland, Ireland, England and Wales, and St Vincent and the Grenadines. Thank you all for joining us today. I'm going to start with a question based on what Lord Kerr said extrajudicially at the end of 2019. He was speaking as part of the UK Supreme Court 10-year anniversary series, and he said, "As I get older, I find that the chance to be provocative is not to be missed." So, Lady Hale, perhaps we could start with you. To what extent was Lord Kerr a provocative judge on the Supreme Court?
Well, he was correct to say that he became more and more provocative as time went on. When he first joined us, having been Lord Chief Justice of Northern Ireland, he was quite a standard law lord. Nothing very startling about what he did and said. But as time went on, he developed a distinctive approach to the cases, particularly in the context of human rights, and was more and more prepared to voice his distinctive point of view, even if nobody else was quite prepared to share it. And the examples that I would give of that are his judgments in the 2 cases about the benefit cap. In the first of those, he decided that he would devote himself to arguing that international treaties could be automatically incorporated into UK law without legislation, which was a very radical thought. And he knew he was dissenting, so he didn't mind doing it. And another example would be his leading judgment in the case about El Ghazouli, the case was called. It was about the UK sending evidence to the United States with a view to 2 people who were accused of very, very serious crimes in the Middle East, with a view to their being tried in the US, without the US assuring the UK that they would not impose or execute the death penalty. Now, Lord Kerr took the view that the death penalty was now contrary to the common law of the United Kingdom, and that for that reason the government could not lend its assistance in such a way that it might be imposed. The rest of us decided the case on the basis of the Data Protection Act. And in fact, the government went along with that in due course. But Lord Kerr went further than any of us had done in a very eloquent judgment, which set out his views on the death penalty. Those are the ones I would point to, more than his judgment in the Northern Ireland abortion case, as indicating his tendency to become more and more provocative the older he got.
Thank you. Yeah, we'll be returning to actually the idea of pushing the boundaries of the law and seeing the way in which the law might evolve through consideration of his judgments. And of course, we will be returning to the Human Rights Commission case on abortion. But if we could get the advocate's view on this, Ms. Anyadike-Danes, of course, you would use a lot of Lord Kerr's judgments in your work, and it goes without saying the obvious authority of such judgments, especially coming from the Supreme Court. But what value do you see specifically in his judgments, and why would you go to them to inform you about the state of the law?
That's a difficult question, as almost anything is about Lord Kerr. For a start, it's actually quite difficult to comment on the influence that a judge has on you, because you don't always know it's happening at the time you're using his judgments. But I would say the influence he had on me, and he's probably, from the Northern Ireland point of view, the judge that's had the greatest influence on me. And it wasn't always because actually I agreed with what he was saying, but I always looked at his judgments because I felt I was trying to see a direction of travel. And I thought, from a judicial point of view, he had the imagination and courage to identify travel. Now, that travel didn't always lead you to a successful endpoint, but it certainly gave you a sort of an out-of-the-box kind of way to look at things. And I very often found myself having to be in that situation and needing to be creative. And I used his judgments from that point of view. I'll just give you one sort of example, and maybe it also speaks to the question that you asked before about whether he became more liberated as he became older or more senior, I would like to say, because I don't think it's actually got anything to becoming older necessarily, but I think it is becoming more senior and more, maybe more confident in his position. I don't know, but I remember dealing with the issue of status in adoption. Lady Hale probably remember this because there was Re-P or Re-G, as it was reported, which dealt with that in relation to unmarried parents. Now, when that decision came to the Court of Appeal, Lord Kerr was then Lord Chief Justice, and the view of the Court of Appeal got overturned at the Supreme Court, and I'm very glad it did. But it's a very interesting judgment to see what happened then. And then I think he was conducting himself in the way that Lady Hale said was a rather more conventional terms. And it fell to me to argue the case in terms of same-sex marriage. And that was another case dealing with status as well. And that was Northern Ireland Human Rights Commission took that case. But it didn't get as far as the Supreme Court, although there was an application to appeal to it, because we succeeded both at first instance of the Court of Appeal. But the interesting thing about it is that when I subsequently, in just thinking about this webinar, realized that over that period of time when the application would be being made to appeal it to the Supreme Court, Lord Kerr was at that time on the panel that determined which cases from Northern Ireland you would receive, and I think he was dealing with about 74% of them. And I rather like to think that he saw that and decided that he was going to, not he personally, but the panel together, was going to refuse the application to appeal because that was all resolved. And I just thought it was such a wonderful irony that the position that he was taking when the first iteration of that came to him in the Court of Appeal was one that he didn't appear to be able to countenance. But by the time several steps on we'd got to it in another form, that matter was absolutely resolved, and we moved on from that issue of status. And I just rather thought that was amusing. But that, I found him very ready to evolve in that way in his thinking. I never found him to be the kind of judge that was constrained by what he might have said previously when it came to another case. So from that point of view, from a practitioner's point of view, he was a very good judge to try. Seriously speaking, when you're looking and thinking, where are we going? What's the direction of travel of this area of law? Who's got the courageous thought on it? Can I use that and align my arguments to that? He was certainly a judge who was the one that I would go to probably first. And
Could I just interject for a moment about that? Because of course I was chairing the panel which refused permission to appeal in your case, and I had been on the court in the earlier Re-P or Re-G case, and of course he had to go along with it, because we all do. Once a matter has been resolved by a higher court, we have to agree with it, and we very rarely depart from it. And it was absolutely obvious what the answer was, and the courts in Northern Ireland had got it right. So of course, but you're right about the direction of travel. Sorry about that, but I thought I wanted to make that clear.
No, absolutely. Picking up on the sort of Lord Kerr's involvement in the appeals going from Northern Ireland to the Supreme Court, Professor Dickson, you did a very detailed look at the sort of first 10 years of the Supreme Court and Northern Irish appeals going up to it in an article with Dr. Conor McCormick, also at Queen's University, late last year in the Modern Law Review. And perhaps you could tell us a little bit about your research and the sort of trajectory that you saw, or the sort of influence, the institutionality of appeals going to the Supreme Court from Northern Ireland, and the influence that Lord Kerr would have had on those appeals.
Yes, well, more so than any of his predecessors from Northern Ireland who went to the top UK court. I think he became very much the go-to person in that court as regards appeals from Northern Ireland. He was on the court longer than any other judge from Northern Ireland, talking about the Supreme Court and the House of Lords, obviously, before it. It has become customary for the Northern Ireland judge, if there is one on the top court, to be involved in the appeals from Northern Ireland. But I think in Lord Kerr's case, that was even more true than it had been previously. And he seems to have played a more active role in those cases than his predecessors did in the previous cases. I think of the 35 appeals, I think it's 35 altogether, that went to the Supreme Court during his time there. He was involved in 31 of them in some form or other. One or two he couldn't be involved in because, of course, he'd sat in the case earlier when it was in the courts of Northern Ireland. But he took on the lead role. He began, he became the person who wrote the lead judgment. I don't know whether that's by accident or design. Lady Hale can tell us more about how the decision is made as to who should write the leading judgment, but it seems clear that he was the person that the court primarily relied upon to get the law in Northern Ireland right. And I'm speculating here, but even in the first Miller case, which of course was a judgment of the whole court, the references from Northern Ireland, I'd be surprised if the section of the judgment dealing with the references from Northern Ireland were not penned or at least heavily edited by Lord Kerr, because his colleagues would probably have looked to him for what he thought about the answer to those issues. So I think he took seriously his responsibility as the judge with knowledge of the Northern Irish legal system on the Supreme Court, and his colleagues, certainly through time, but from very early on in his time on the top court, they were willing to rely upon him to play that role.
Thank you. We will come back to the topic of a Northern Ireland voice in the Supreme Court in a bit. But before we get to that, I was wondering, Professor Archibold, could you tell us a little bit about Lord Kerr's time as Lord Chief Justice, and in particular, the administration of justice while he was the Lord Chief Justice, which isn't really a side of a judge that is very widely considered in the public, and his interest in making sure that there was access to the courts.
So I was Lord Kerr's legal secretary when he was Lord Chief Justice from 2006 until he went to the Supreme Court. And the legal secretary is the leader of the legal unit, which is a research unit that he really envisaged and set up when he was Lord Chief Justice, but also part of the office which runs the courts in Northern Ireland, because you'll remember that um, just before this, in the 2002 Justice Act, a lot of the functions of the Lord Chancellor had been um, devolved to the Lord Chief Justice of Northern Ireland. And this was in the period when we were waiting for the whole of the justice system to be devolved. So he had a lot more duties than his predecessors had had as head of the judiciary, and as having a lot of responsibility for the running of the courts. And that meant that he did less judging as Lord Chief Justice than he might have in former times, although there were a number of big cases that he sat on. Re P was one. Another was, it was called Re C and others in the Court of Appeal, but it was Re McGee when it got to the Supreme Court about the surveillance of prisoners' correspondence and prisoners' conversations with their solicitors. So I think what my overwhelming impression of him at the time was that he was a great advocate for the adversarial system. He believed in the court process, but he was aware of the pressure that the court system was under through the numbers of cases that there were, the lack of time there was to prepare, the pressure on the judiciary. And he was looking with a helicopter view at how to make sure that justice was done in cases across the system rather than just in the cases that came before him.
It's interesting, of course, that you mentioned the Reece, the McGee case that went before the Supreme Court. That was one of the more controversial cases at that time concerning whether or not solicitor-client communications could be subjected to surveillance under the Regulation of Investigatory Powers Act. And the Court of Appeal came to one conclusion, and the Supreme Court came to another conclusion. And I wonder, Professor Archibold, if you could go into when Lord Kerr sat on the Reece Court of Appeal panel as Lord Chief Justice, how he managed to, within the adversarial system, how he managed to balance these sort of conflicting arguments between the right of a person sitting in a police station to have legal advice and for that to be protected, and the statutory surveillance mechanisms under the 2000 Act.
It was an interesting judgment because it's a case where it would be very easy to take one of two views, either to say, well, this is appalling, this is dreadful, this should never happen, or to say, well, REPA says that you can do it, so you can do it. And that was a case where he, as I think was characteristic of his judgments then, used a very rigorous legal analysis to look at the safeguards that there were, and to acknowledge that there might be situations where an independent and enhanced authorization would permit it, but not to have a routine or a thoughtless infringement of rights. And again, he based himself very much in the convention in that judgment. But there's, at the time, he gave a speech which unfortunately isn't on any websites, because it was before we put speeches up on websites, on judicial deference in 2007. And I think that was a speech where he was thinking about what is the role of the independent judiciary, and how are there areas where, and again, you saw in Re P, where he very much said, this is something for the elected institutions, it's not something for us as judges. His thinking about the relationship between the executive and the judiciary. But by the time we get to Northern Ireland Human Rights Commission, towards the end of his time in the Supreme Court, he nodded to the idea that this might be a matter for the elected institutions, but said that, of course, the Northern Ireland Assembly wasn't sitting at the time, and therefore it was something which the court would look at and would take decisions in. So I think that his time, I think Rees is an interesting case from his time as Lord Chief Justice, because it also possibly reflects an understanding of the different role of the Court of Appeal and the Supreme Court in the lexicon of the Constitution.
Yeah, that's a very interesting perspective, because, of course, we tend sometimes rather casually to conflate judicial viewpoints along a sort of spectrum, thinking that some judges are conservative, some judges are liberal, and that's just the way they are. But of course, there is a hierarchy, of course, that we have. And the Court of Appeal is limited in its own space by the authorities handed down originally from the House of Lords and then currently the Supreme Court. And so within the Supreme Court, I suppose, there's greater freedom, and perhaps Lady Hale can shed more light on this, greater freedom to consider whether or not actually the state of the law is correct or should move.
Well, of course there is, because the Supreme Court, like the House of Lords, is not bound to follow any of the decisions of the lower courts. And in exceptional circumstances, if justice requires it, they can even depart from their own previous decisions. So they have a much greater freedom than any of the lower courts have, whether it's in Northern Ireland, England and Wales, or Scotland, to think things through from a basis of first principles. That doesn't mean to say that the Supreme Court is making it up as it goes along, far from it. But it is trying to look at things as a matter of principle. And I would also like to agree with the point that a judge's thinking and approach can develop over time. And I would very much agree that that is what happened with Lord Kerr. As I said earlier, when he joined the House of Lords as the very last Law Lord ever appointed, we didn't have any particular impression that he was the great forward-thinking liberal that he subsequently became or emerged as. I think he would say that he emerged as such, and that people who had known what he was really like when he was in Northern Ireland would have understood that.
One of his most, I suppose, keenly awaited, certainly in Northern Ireland, one of his most keenly awaited opinions was in the Human Rights Commission case. And at the time that the Supreme Court handed down judgment in that case, there was a considerable amount of coverage of the judgment, both within the sort of legal practice and academia fraternities, but also beyond. And Lady Hale, if we could discuss that judgment itself, because it was so unusual, both in what it became, but also in, it was landmark in the issues that it had to consider. Never before had the whole state of abortion law in Northern Ireland been scrutinized to such a degree against the European Convention on Human Rights. And the net result of the judgment was to split the court into two.
Three.
On the
Three.
Actually, yes, it is three. A loss on the procedural standing point for the commission, but an overall win on the substantive position that, in fact, abortion law breached the European Convention. And perhaps, Lady Hale, you could tell us a bit about what it was like to be on that panel and the contribution that Lord Kerr made both to the overall thinking in the case, but also given his knowledge of Northern Ireland and the particular social and political circumstances that would have been the backdrop to that case.
Well, obviously, there are things that I cannot talk about. You'll understand that. It's not open to me to reveal the deliberations that took place between the justices in the case.
Sure.
The thing that is, of course, remarkable about that case is the position of Lord Mance, because Lord Mance was, with the majority, firmly convinced, very firmly convinced, that in the three respects that we discussed, Northern Ireland abortion law was in violation of the right to respect for family life, private and family life, protected by Article 8. But such was his intellectual honesty that he was equally firmly convinced that the Northern Ireland Human Rights Commission did not have the standing to bring the case. So you do have to admire that. I took the view that Lord Kerr would be the person who had the clearest understanding of the thinking and background to the role of the Northern Ireland Human Rights Commission, and that if he considered that it was within their powers to bring the proceedings, he was likely to be right. I also independently, of course, read the legislation and convinced myself beyond doubt that he was right. So that was the frustrating thing about that case. We perched on different branches in relation to the violation of the convention because, in fact, 5 of us considered that in relation to fatal fetal abnormality, it was a breach of the convention, because Lady Black joined us in that, but she didn't join us in the other 2 respects. And of course, Lord Kerr and Lord Wilson considered that not only was it in breach of Article 8, it was also in breach of Article 3, inhuman and degrading treatment in certain respects. So it was a complicated alignment of views with different people perching on different branches of the tree. And a lot, I can say this, there was a lot of toing and froing, coming and going, thinking it all out very fully and carefully. For example, on the question of incest, we did a lot of thinking about that, which was way beyond what had gone on in the arguments in the court. So yes, it was a case about which we all agonized, I am sure. But Lord Kerr was the one to whom I turned on the basic question of the powers of the Northern Ireland Human Rights Commission.
Can I just interject there?
Yeah, sure.
2 points. It's interesting that when he was a judge in Northern Ireland, he was involved in the first Human Rights Commission case that went to the House of Lords, which was again about the powers of the Commission to intervene or to apply to intervene in court cases. And he alone amongst the judges in Northern Ireland thought that the Commission did have that power. He was very, well, I was about to say very pro the Human Rights Commission, but he saw how important the Human Rights Commission was as an institution established under the Good Friday Agreement. And just by the way, I think he can go down as a very big supporter of the Good Friday Agreement. And he strove to interpret legislation to make it compatible with that agreement when necessary. But it's interesting as well that this whole issue of abortion is one which might provide evidence for how he developed his judicial thinking, because when he was a judge in Northern Ireland, he, sitting as a single judge, dismissed an application by the Family Planning Association asking for a court order requiring the Department of Health to issue guidance on the law on abortion in Northern Ireland. And he somehow came to the conclusion that there was no need for guidance because the law was quite clear, and that practitioners, medical practitioners, knew exactly when and when they could not carry out an abortion. I think we can see that his views shifted a bit. Of course, a lot depends on the wording of the legislation in question and so forth, and the law could be certain but bad. But I think he did shift his position on that issue when he got to the big abortion case brought by the Human Rights Commission in Lady Hale's time.
Yeah, maybe I'd like to say a couple of things about what's been said so far. The first about whether the human rights case was the first to really call for judicial scrutiny in relation to the law on abortion in Northern Ireland, and be subjected to the kind of analysis that happened in the Human Rights Commission case that Lady Hale sat on. I'm not sure that's entirely right, actually, because I think the context for that had already been provided in the AB case. I think both Lady Hale and Lord Kerr were on. In fact, there's a very, very powerful, just short description of where we were. I think it was given by Lord Wilson, I think, yes, right at the beginning. And he gives from A through to L the most extraordinary synopsis of the position that young women and girls, and any woman really requiring that kind of healthcare faced in Northern Ireland at the time. And of course, there, both Lady Hale and Lord Kerr were dissenters in that. And that goes to something else, I think, Anurag, that you were saying, which is the power of dissenting. And what I remember that case more for is how it set it up for a change in terms of enabling women coming from Northern Ireland to England to have access to free termination. The fact that they were dissenting judgments was irrelevant to the power that they had in that case, actually. So that's one point I wanted to make. The other point in relation to the Human Rights Commission case when it came to the Supreme Court is, firstly, I do want to very much agree with Lady Hale as to the power of Lord Mance's judgment. It was an extraordinary judgment to read. Only extraordinary because how powerful it reads off the page when you read it. And right at the end, of course, he was quite prophetic. In fact, I latched directly onto right at the end, which is that if anybody wanted, notwithstanding the fact that the whole thing was arbitrary in many respects because there was no standing, but if anybody wanted to take that case, it would be very difficult to see how it might be resisted or worse to that effect, which is right at the end of his judgment. But that's, of course, exactly what we did do in the UJR. So he provided that springboard. But to go back to that case in terms of Lord Kerr, his judgment was very powerful for different reasons, apart from the fact that he was only one of two that found it was a breach of Article 3, which is a very, very powerful thing to see for those working in that field in relation to that area of law, but also in a way to the voice he gave to all those who, as he described them, are courageous enough to give their testimony. It's a very difficult thing to give testimony about that sort of thing, certainly still in Northern Ireland. It really was. And he gave them a space because he recorded so much of what they had said in their affidavits in his judgment. Whether he knew the power of him doing that and the effect that it would have on those people who gave that testimony, I don't know. But having worked with certainly two of those, it was an extraordinary moment for them to read that in a Supreme Court judgment. The other thing, of course, it did, along with all the others who went on to give judgments on the substantive issues and not to be stopped at just the fact that they couldn't agree in a majority way that the Commission had standing. The other thing that it did is it continued the spotlight on circumstances in Northern Ireland, and that again provided a means to see change in the law, and that's precisely what happened, not necessarily in the way that people thought it would, but nonetheless it did happen, and we're still wrestling with the outworkings of that now, but nonetheless it occurred. And so that's just what I want to say about the power of a judgment, whether you're in the main swing of what the other justices are saying, or whether you're saying it in your own particular way, dissenting or no, one should never lose track of how powerful that is. And sometimes when you stand up in court and you read an extract of a judgment like that, it is a good moment as an advocate to have those sorts of judgments to be able to read from.
Yeah, no, I'm glad that you mentioned that, Monye, because it was something that struck me about that judgment, those very powerful statements that he made of the circumstances of the women who were associated with the Human Rights Commission's application, and it reminded me of the judgments that he would give in sentencing appeals when he was in the Court of Appeal, where he always took the time to say what the impact of the crime had been on the victim, and not just to read out the victim's statement, but to give time to the victim or their family. And I think that was something that certainly always struck me about his criminal judgments, that he gave time for people to be heard, and he never lost sight of the fact that there were individuals behind these very complex, sometimes doctrinal issues. And I think that the Human Rights Commission case was a very good continuation of that part of his judicial practice.
Yes, and the humanity, I suppose, in Lord Kerr's judgment, so the focus of Lord Kerr on these sort of particularly sensitive matters, and the humanity that he showed in them, I think also extended Professor Archibold to those with whom he worked. Certainly, I think while he was Lord Chief Justice, and to another extent, while he was a Justice of the Supreme Court, because Lady Hale, it's true, he was in charge of the judicial assistance scheme in the Supreme Court.
He was in charge of recruiting to the judicial assistance scheme in the Supreme Court. And so, although obviously, because they were going to be employed as temporary, not graded civil servants, but temporary public employees, our personnel officer had to be basically involved. But there were always justices involved in the selection of the shortlist, and then in interviewing the shortlist, and then in the selection. And Lord Kerr was the one in charge of all of that. And he also took a great interest in the young people who came to work with us for just under a year, and was very concerned, obviously, about their development and their welfare. But I think he also took quite an interest in the welfare of his colleagues as well. He was one of the most senior members of the court towards the end. He presided quite a lot, but he was a great peacemaker. You know, if things were getting a little bit fraught, which just occasionally they could, where people disagreed with one another or something happened, Lord Kerr would always be the one to come along and try and make peace. I mean, other people did it too, but he was particularly good at that because he was on good terms with everybody. And we always used to say the astonishing thing about Lord Kerr was the warmth of his heart and the iciness of his room. He kept his room at a temperature which meant that most of us would refuse to have meetings there because it was so cold. And in fact, eventually, he had to warm it up a bit because it was killing all his plants. But the contrast, as I say, between his temperament
Yeah.
and the temperature of his room was remarkable.
Those are certainly things that I would remember
Um,
as well. Yeah. I know that
yes, Professor Archibald, I was just going to come to you and ask you about his time as Lord Chief Justice, and yeah.
there was a reason why I wore wool scarves throughout my time as his legal
Yes,
secretary.
yeah.
Because but no, um there was there was a staff of probably around 30 people in the office of the Lord Chief Justice, and it was a mark of his temperament that he would give us a Christmas supper every year, at his own expense, and until our numbers got too great, at his own house. And there was something about, I mean, Sir Declan Morgan, his successor, has very much done the same thing, but he was someone who you wanted to follow. He was excited and energized by the work that he did and by the cases before him, and he brought us into the circle. I mean, we were junior and mid-ranking civil servants, but he he made us feel as if we were part of something important. He always took the time to, for example, when we did a piece of research for him, he would ask, "So what do you make of the point?" And we would stumble and stutter our way through what we thought, because particularly when you were new to the office, that was a completely terrifying experience. But um, it really developed us all as lawyers, and we knew that he took an interest in us, not just in the work that he could get from us.
I think we can see sort of testimonials, certainly testimonials from judicial assistants who have been in the Supreme Court and who are still at the Supreme Court, who speak extremely warmly of Lord Kerr, but also not just within the legal profession, but also Lord Kerr made connections with academia and with legal academia in particular. Professor Dickson, perhaps you could tell us a little bit about the judge in residence scheme that Lord Kerr started when he was Lord Chief Justice.
Yes, I'm not sure if he started it, but he certainly supported it very much, and thought it was one of the more important roles that the various High Court judges are asked to play in Northern Ireland, supplementary to their judicial roles. He was very keen on that, and he himself, would attend events, prize givings, and the like. He would invite academics to give talks for the Judicial Studies Board. He himself attended academic conferences. We have to remember that when he was appointed Lord Chief Justice, I mean, he was the first Chief Justice to be appointed after the Good Friday Agreement. And he was different from his predecessors, not just in personality, but because of the times. He was able to be more publicly facing than his predecessors, who were reluctant to get out and about or to make public statements, A, because of the security risks, but B, because of the political sensitivities of this place. Brian Kerr was able to navigate the difficult political sensitivities here very, very well, I thought. He knew when to speak and when not to speak, but he didn't hide away. He was a pretty public figure, and his successor, Sir Declan Morgan, has certainly followed that model, and is now quite a a political animal with a small p, soon to retire, unfortunately. So yes, I think he was a friend of academics, a respecter of academics. He didn't himself give that many lectures, I think, compared to Lady Hale and other people who held the presidency or the deputy presidency of the court, the Supreme Court. But he did give speeches more so than his Lord Chief Justice predecessors did when he was in Northern Ireland.
As a sort of follow on from the kind of public facing role that Lord Kerr was increasingly comfortable with as Lord Chief Justice, and indeed following his retirement, he gave a lengthy interview in The Guardian discussing a number of things, including the rule of law and the role of the Supreme Court, particularly given recent cases arising out of Brexit and judgments Miller 1, Miller 2 Cherry, and so on. And so I'd just like to ask, first of all, Lady Hale, Lord Kerr mounted a pretty robust defense of the Supreme Court as an institution, as an incredibly important, but also as an essential institution in the proper constitutional functioning in the United Kingdom, and that any change in its substantive role should be resisted. What is your own view of the sort of position of the Supreme Court in the constitutional functioning in the United Kingdom?
Well, as I always say, there are three good reasons for having a Supreme Court which has final jurisdiction in respect of all parts of the United Kingdom. One reason is a mundane one, which is that because we take so few cases, we can give them more attention, and because we're not bound by others' decisions, we can think in a more principled way, and there are more of us, and we have more help, and so our decisions ought to be better than the decisions in the courts below. I'm not claiming that they always are, but in theory they ought to be. So that's number one reason for having us. Number two reason for having us is that there is a great deal of law which is either the same or nearly the same throughout the United Kingdom. And clearly we need to have consistency in the application of that law and the interpretation of that law. And only the Supreme Court can give an authoritative decision which is binding on the courts in all parts of the United Kingdom. But the last reason why we need the Supreme Court is as the guardian of the Constitution of the United Kingdom. Part of that, of course, is, this is perhaps the wrong verb, but the policing of the devolution settlements to make sure that the devolved institutions are acting in accordance with the powers that the UK Parliament has given them. But part of that, of course, is also ensuring that the UK government acts within the powers that the law gives to the UK government, and that the relationship between the government and the sovereign parliament, the UK Parliament, is properly respected. All of that is what the Supreme Court is for. And that I would thoroughly endorse Lord Kerr's ringing defence of the Supreme Court. Of course I would. You wouldn't expect me to say anything else, would you?
No. I think really Lord Kerr represented, certainly personified himself and all of his colleagues, the value of the Supreme Court as an institution, both in terms of its output, but also really in having a sort of final check on the development of the law and a final scrutiny of the development of the law. And of course, one of the great cases where Lord Kerr dissented but was ultimately vindicated, and Professor Dickson, you brought this case into your article, was the case of Cochrane, where it was about retention of photographs and fingerprints and DNA profiles, where the Supreme Court ultimately said it wasn't an unlawful interference or disproportionate interference with convention rights. Lord Kerr disagreed, and Strasbourg ultimately sided with him. Professor Dickson, perhaps you could tell us a little bit about the sort of reasoning that Lord Kerr had in saying that the Supreme Court shouldn't ultimately only seek to keep up with the Strasbourg court, but maybe go beyond it in certain respects.
Yes, his attitude to the so-called mirror principle or the Allah principle. Well, he was consistently discontent, I think, with the idea that the no more, no less principle was an absolute one. He never really agreed with it, I think, and he made that clear through dicta in his judgments and through statements in his lectures. He thought it appropriate, and I would go so far as to say, Lady Hale can correct me if I'm wrong, but I would go to so far as to say that his view is now the mainstream view amongst most of the senior judges. They don't well, they might hesitate, but they are prepared to go beyond Strasbourg when necessary, and they see the relationship to Strasbourg as very much a dialogic one. They're in dialogue with their colleagues in Strasbourg. They're not subservient to them. I know Lord Kerr gave a lecture called "The Modest Underworker," the role of the Supreme Court as the modest underworker for the Strasbourg court, or something to that effect. I think in his judgments and his speeches, he made it clear that when appropriate, and obviously it has to be only when appropriate, the Supreme Court should push the envelope a little and go beyond even where the European Court has gone. Most obviously in situations where the European Court hasn't yet spoken. I mean, Lord Hoffman, for example, who's often thought of as a rather conservative judge when it comes to the work of the European Court of Human Rights, and gave a speech and wrote an article which was rather rude about the European Court in some respects. But even he, in the P case that's been referred to already, the G case, the adoption case, was prepared to go beyond where the European Court had yet gone, because the European Court had never said there was a right to adopt a child. But Lord Hoffman said, well, once a state confers the right to adopt a child, it must not discriminate in who can adopt. And I think Lord Kerr was very much in that school of thought. He was prepared to push the envelope vis-a-vis convention rights. At the same time, and I think it's important to stress this, he was very much in favour of developing the common law, perhaps as a safeguard against the day, God forbid, that the Human Rights Act is ever repealed. But I think he saw it as part of his mission to bolster the common law, especially, for example, in that El Ziguli case that Lady Hale referred to at the beginning of this podcast, but also in other cases to do with the right to life, especially. He was in favour of saying the common law should keep pace with the European Convention, a view which I would very much support myself. So yes, I hope that Allah is more or less dead, partly thanks to Lord Kerr.
Well, maybe Lady Hale could shed some light on her views. Is Allah dead?
Well, half of Allah is definitely not dead. Because what, of course, Lord Bingham said in Allah was that we should keep pace with Strasbourg jurisprudence as it developed over time. And his point was, he said no more, but certainly no less. It was Lord Brown who later on said, in effect, no less, but certainly no more. But in fact, I think most of us would take the view that if it is clear that the United Kingdom is going to lose in Strasbourg, well, then we should probably go along with what Strasbourg has said, if that is clear. In other words, no less, unless we have very grave reservations about where Strasbourg has gone, which just does occasionally take place, but only occasionally. If we don't know what Strasbourg would do with a case, well, then obviously we have to try and work it out for ourselves. And the Rabone case about the suicide of a psychiatric patient is a good example of that. And Lord Brown agreed with that as well. If we may be going further than we think that Strasbourg did. Well, then most of us, if we think it is right in principle, would be prepared to do that. And it is quite often the case that Strasbourg catches up with us. And no doubt the Goffrin case is an example of that. And there have been others as well, where, yes, Strasbourg has agreed with us. One of the problems in the Northern Ireland Human Rights Commission abortion case was that Strasbourg had said that this was within the margin of appreciation for the member states. This was particularly in relation to the Republic of Ireland, because at that stage, Strasbourg was very keen to be sensitive to the particular concerns in the Republic of Ireland. And because of that case, some of the members of the Supreme Court panel were not prepared to go further than they thought Strasbourg would go. And that was one of the difficulties about the knife-edge decision as to whether or not the Northern Ireland abortion law did contravene the Human Rights Convention. So I'm saying all that because my views are very similar to Lord Kerr's on this, as you would expect, but not everybody has taken exactly the same view, I would say, particularly where something is regarded by Strasbourg as within the margin of appreciation. We could talk about the assisted suicide case of Nicklinson, for example, where Lord Kerr and I took the same view. But that was going beyond. It was taking the principles which Strasbourg had adumbrated, but it was going beyond anything which Strasbourg had actually decided to date.
Yeah, I think this goes back to what Ms. Anyadike-Danes was talking about earlier in terms of the direction of travel, in a way, because if the Supreme Court were to go beyond Strasbourg, then it might flag up a direction of travel for Strasbourg itself. Something that Strasbourg may have avoided out of a desire to be sensitive to a margin of appreciation earlier, but then latches on to what the Supreme Court says and follows that reasoning. I wonder, Ms. Anyadike-Danes, whether you would talk about the confidence of Lord Kerr's judgments as time wore on, to be sort of as forthright as he was. Does that give you as an advocate, does that give advocates a sort of confidence in trying to be creative or trying creative arguments, trying to push the boundaries themselves at the bar?
What a question. Well, before I come to that, I'll let that settle with me. Before I come to that, to follow on from what Brice said, I think you were very nearly right with the title of that talk by Lord Kerr. I think it was the UK Supreme Court, the modest underworker of Strasbourg. I think it was in his Clifford Chance talk. I only know that because he didn't do that many of those sorts of talks. But to come to your question, because I'm not avoiding it, well, I think it would be hugely presumptuous of me to talk about whether Lord Kerr did or did not become more confident in his judgments. I would have thought by the time that any judge gets to the Supreme Court, they're pretty confident in their judgments. But if and whether or not that allows an advocate to be more certain about trying to gauge the direction of travel, I can't speak for advocates generally. That's another thing I would presume to do. But for myself, it actually wasn't that. It was more the quality and nature of his argument that I was looking for. I was looking to see where he had tethered or connected himself to something that I could see that's fairly solid ground of where there might be a consensus of where we were, and how he got to somewhere else which I might align myself with, because that's where I wanted to go in my argument. So it was more the quality and nature of his analysis that I was looking for. I wasn't thinking, well, this is a fairly confident sounding judgment of Lord Kerr. I think that'll be impactful if I refer to it. It wasn't really like that at all. I was an admirer of his analysis, but he's not the only one that I admired for that, because there are many judges I admire for that. We happen to have one of them on the panel right now, sparing her blushes. It really wasn't that. It was the feeling that, and maybe this came from his facility to dissent, it was the feeling that he did not always feel overly constrained by his jumping off point, and that enabled a certain jumping off. And that's what I was looking for. I was always looking for how can I take further where we currently are, because where we currently are probably isn't overly serving my argument. So I want to know how I can move from that. And so he was quite a good judge for me to try and look at that, because to me, and I didn't know him personally, so I have no idea whether he did this consciously or intended to do it, but he seemed prepared to do that. Within, obviously, certain constraints. He wasn't completely unmoored from anything. And that's why I found him interesting. Whether that was his confidence or not, I cannot speak to that because I don't know. But it certainly was a facility for his creative thinking that I was looking for. Grounded in analysis, not just creative thinking for the sake of it.
It's interesting what you say, Monye. Um, for me, watching his reasoning develop over time, he was someone who didn't see the law staying still. And particularly in judicial review, I think he very much enjoyed his time as judicial review judge in Northern Ireland. And I noticed that one of the judgments he gave then, Tracy and MacDonald, which was a case about the oath which senior counsel were required to take when they took silk in Northern Ireland, he made an observation that the courts in the United Kingdom have not entirely closed their minds to legitimate expectation. And then again, in Finucane, which was one of the most recent judgments in the Supreme Court, he was setting out the whole of the development of the doctrine of legitimate expectation since then, and and again, almost laying a trail of crumbs for its development, or for he thought it should be sitting. But I think he very much had that sense that the law does change. And that's why I was interested by his judgment in Adams, where he was throwing a little bit of shade on Carltona. And I would have been will be fascinated to see where that one goes in future as well.
Of course, because there's already proposals for reforming, or statutorily, I think, reforming the Carltona doctrine in light of the Adams judgment. So it will be interesting to see the legacy of that and the legacy of the nuance that Lord Kerr brought to Carltona in his decision in Adams. I just wanted to ask any sort of final thoughts on Lord Kerr. I know it's terribly difficult to encapsulate such a lengthy, interesting career, but because we are short on time, any sort of final thoughts on Lord Kerr as a jurist, as a judge? Lady Hale?
Well, he was a great judge and jurist. I completely agree with Professor Archibold that he did see the law as on the move, continually capable of development. And he saw that in relation to the common law, and he saw that in relation to the human rights jurisprudence. So he was a great beacon. We didn't always agree with him, but he was a beacon for us all. And my one regret is that I couldn't persuade him to agree with me in the Kew case about the Malayan massacre in 1948, when even he could not persuade himself that the government's refusal to have a public inquiry now to try and put the pieces together of the Malayan inquiry and the British inquiry was irrational. I thought it was a rare example of an irrational decision, but I couldn't persuade Lord Kerr to agree with me. One of the biggest disappointments of my judicial career, and very unusual from his point of view.
Thank you, Lady Hale. Professor Dickson, any final thoughts?
Well, I would just endorse what Lady Hale has said. I think he is probably the best judge to have come from this corner of the world. And those of us who live and work and operate the legal system here can be justly proud of the contribution he made to the development of the law throughout the United Kingdom. He was inspirational to many people, I think, and it's just very, very sad indeed that he died so prematurely.
Professor Archibold.
Lord Kerr gave one of his last conference speeches to us in Government Legal Service in Northern Ireland, and one of the questions at the end was someone had a son who was thinking of doing law, and what advice would he give? And the advice that he gave was that you should do law because you want to do it and that you should enjoy it. And I think that looking back over his career, you see someone who very much enjoyed putting his very considerable gifts to good use in law. And I'm just sorry that we lost him too soon.
Thank you. And Miss Anyadike-Danes, any final thoughts?
Yes, well, I have to say, given my particular interest, I rather share the disappointment that Lady Hale had about the Cave public inquiry, but we'll leave that to one side. Well, one thing actually hasn't been said of him, although I suppose perhaps tangentially it has, and that is his generosity in giving of himself at his time. And he always struck me, as I say, I didn't know him personally, but he always struck me as somebody who loved the law. The law, its development and its significance and its potential impact. And I remember, I think he gave one of the first lectures or presentations in relation to the gay pride. It was something that was sort of gaining in popularity in Northern Ireland. It being a very, very difficult thing to have a gay pride march in Northern Ireland, frankly. And pretty much unheard of when I first came to Northern Ireland, that anybody would openly declare themselves in that way. But anyway, by the time he got round to inviting Lord Kerr, he had no qualms whatsoever about coming and giving, let's put it this way, a very robust Chatham House presentation during that week, which was immensely inspiring. But it happened at a time when he was doing so much else, and the fact that he could agree to come and do something like that to a relatively small audience, I suppose, I just thought that said something about him. It really did. And then there were other times when I've seen him come and be prepared in a group of lawyers to agree to come and give a presentation. It's nothing that's going to hit the headlines anywhere, but he's just making himself available. And as Claire said, his very great judicial talents and his skill with the law available to others to see and to take and do with what they will when they apply it in their own lives or their own work. Yes, he was a very generous judge from that point of view, and I share with others the disappointment that he's no longer here. But if he had to go, he went when he was still planning things to do, and he was and still active and busy to all accounts, and that I suppose is something.
Yes, I think in years to come we'll be still talking about the legacy of Lord Kerr because it will be an indelible legacy to dissect and to be influenced by for years to come. I would like to extend our sincere thanks to Lady Hale, Professor Archibold, Professor Dickson, and Miss Anyadike-Danes for giving us their time and their insights into the career of an extraordinary judge. We hope this provides an insight not only into Lord Kerr as a judge and a jurist, but also more broadly the role of a judge, especially within the higher courts in Northern Ireland and the UK. For more information, please check out our blog on the LawPod website, where we will list all of the sources referred to in the episode, and a forthcoming book entitled The Judicial Mind, a Festschrift for Lord Kerr, edited by Professor Dickson and Dr. Conor McCormick, with contributing chapters from Lady Hale and Professor Archibold. You can also follow forthcoming episodes in the Legal Lexicon series on Twitter @QUBLawPod.